Well, good morning, everyone. That's going to be a tough act to follow, but we will try our very best. I just wanted to introduce this session by saying that we're looking at AI in the disputes world, and by that I mean we're distinguishing it from how AI can help disputes lawyers in their work. If we have time, and I think we probably won't, we might come onto that subject at the end, but what we're really focusing on is how AI impacts disputes and how the law can adapt and change to meet the challenges that AI brings. So just to frame the discussion, I thought it'd be quite interesting initially, because we hear so much about AI, it's always a topic of discussion amongst friends around the dinner table, in restaurants, but what is it that we mean about AI in a legal context? And in order to sort of frame the challenges I think we're facing, I think an initial question that I'd like to ask the panel is what do they understand? What do they see as AI? What do they understand by AI? Because they all they're all very experienced, very distinguished. They work in the AI field, but I think we can all benefit from their knowledge and their experience of working with AI. So let's start with you, Donia, if we can. So you're Deputy General Counsel at G42, which is an exciting Abu Dhabi-based company that has a mission to build what it calls the intelligence grid. Already it has 10 companies in its portfolio. And whilst I've been waiting, I've heard how exhausting that's been as Deputy GC, acquiring those companies. But what are they doing? What's G42 doing, and how is it using AI in its portfolio companies?
Thanks, Graham. Yes, so we are doing a lot indeed. At times, very hard to keep up. But for us, maybe I'll just explain actually what the intelligence grid is initially for those that may not know. But it's essentially a concept that embodies the vision our group CEO at G42 has, which is the vision is that AI will become almost like electricity in the future. That's the way that he sees it. It will become readily available and it will infiltrate our daily lives, and everybody should have the right to access it. And so with that vision in mind, G42 has sought to create or establish a number of portfolio companies. I think we are at 10 now, if I'm not mistaken, and all of them cross multiple sectors. So, for example, we have CPX, which is one of the more recent subsidiaries, and that focuses on cybersecurity. We have Casna, which is one of our joint ventures between G42, MGX, and Silver Lake. And that's really our data center business. And then we put Core 42 on the top, which is the infrastructure layer. You know, they're the ones that are putting in the servers, the GPUs in the data centers. We also have Inception, which focuses on advanced AI models, your large language models. Some of you would have seen, the announcement that we're looking to do collaborations with OpenAI. And there are several other portfolio companies across different industries, including M42, which of course is the joint venture between G42 and Mubadala, and that focuses on combining G42's digital healthcare and Mubadala's hospitals. The list kind of goes on. But all of these portfolios are kind of established with a view to ensuring that AI spans multiple industries and sectors, but connect in a way that, we can benefit from AI in our daily lives.
Magda, that's interesting. Magda, you're the General Counsel of AIQ, which is more focused on the energy sector. What is it that AIQ is doing or looking at in the AI space?
What aren't we doing? So actually, I love what Donia was saying about AI being electricity, because what AIQ is doing is actually we already look at the symbiosis between energy and AI. So we're a joint venture between ADNOC and Presight, another one of the G42 companies. So essentially, when we think about AI, we're taking data, we're taking insights of years and years of activity in the oil and gas and energy sector from ADNOC, NOCs, IOCs, and then we're combining them with supercomputing capacity from the G42 group to create AI solutions for the energy sector. So in reality, what does that mean? It means that we're utilizing those data insights to automate, to bring efficiency, to bring productivity, to bring sustainability to the energy sector. And just by way of example, one of our kind of key products that we have, Energy to the Power of AI, which we've developed in alignment with Inception, Microsoft, and ADNOC. If you look at seismic interpretation, an activity that did take, for example, months and months, we now utilize our seismic agent to do in the matter of minutes and hours.
And Danny, it's interesting. I call them startups, and that would be probably slightly offensive. They're not startup companies. They're now well-established companies. But AI is also used, isn't it, in established companies globally. It's not so that there are companies, obviously, that are focusing on AI. I hate the word, but I use it. Solutions to sort of foster and generate sort of efficiencies in their own spheres. What are you seeing in that space with your sort of client base?
Sure, happy to address that. And first, let me just thank our hosts. You cannot do AI and not visit this region. I've been here 6 times in the last few months to the Gulf, and G42 and AIQ are 2 examples of the excitement of what's going on here. So what are companies doing? Companies are dramatically rushing to implement generative AI across their business structures. My practice really divides into 2. I've got the innovators, so the LLM, large language model makers of the world, but it's also the business.
Sorry to interrupt. What's large language?
We'll get to
model?
that. We'll discuss
Okay.
that. That's a great question, and it gets to the legal liability issues we're going to talk about. LLMs, just a quick, those are the engine behind the chatbots that you're all familiar with. So if you've spoken to ChatGPT or Claude or Gemini or some of the other foundation models, those are powered by large language models, which is the new version of artificial intelligence that's based on human language and can talk to you, and you can talk to it just like you would a friend or a teacher or a student. So that's really the engine driving. And the key is language, because that's what you used to have to be a data scientist to implement these tools throughout companies. Now, I have Fortune 500 companies where every employee is their own data scientist because they can speak to these agents, to these large language models, and create their own internal solutions to business problems. That brings great opportunity, but it also brings incredible risk to the integrity of information throughout the organization. So I've worked with 6 of the Fortune 10 on multinational governance programs to make sure that AI is deployed in a way that is additive to the corporation and doesn't create embedded issues. And it is a big project because you've got global regulation, you've got increasing global litigation, but most importantly, you've got a technology that's new and people are still figuring out the best ways to implement it effectively. I always say focus on ROI, but responsible AI drives ROI, so it's part of innovation.
And Minesh, you and I discussing earlier some of the sort of legal challenges. So before we move on to the sort of disputes world, why is it, do you think, and I've split this into 3 separate questions, but why is it you think that AI is likely to create disputes? I mean, on the one hand, it sounds quite obvious that it will, and on the other, throughout time, and I'm older than a lot of people in this room, but we've had new technology throughout time, and you don't hear as much about the possibility of disputes with developing technologies as you do with AI. Why is it specifically with AI, do you think, that we're staring at dispute scenarios?
I think there are probably 3 reasons. I think the first is scale. We've already heard from the panelists how much AI is being used. It is going to be everything, everywhere, as the term goes. I think the CEO of IBM a few years ago said that every company is going to be an AI company. So it is going to be a ubiquitous technology, and the way to think of it is as the way that other technologies are being powered. So it's going to be everywhere. So the scale of it means it's inevitably going to create legal issues. The second, I think, is a unique feature about AI compared to other technology, which is how it operates. if you think about conventional software, it's worth thinking about that in the sense that it's automated, it follows human-based rules, it doesn't operate autonomously. Conventional software can't operate outside of the bounds of the rules that humans have created. The essence of AI is the opposite of that. It's to give computers, software, the autonomy to make decisions for themselves, to produce independent output. That means that AI is unpredictable, unforeseeable, and it means inevitably that there are going to be unintended outcomes, and of course, that generates disputes. And I think the third reason is that, as we'll come on to discuss, our liability frameworks that we have currently in the world in all jurisdictions have been developed with humans in mind. When we think about concepts such as foreseeability, causation, which drive the disputes world, drive where liability sits, they're all about humans doing things or not doing things. And when we're dealing with now machines that can operate autonomously, we don't yet have mature enough legal frameworks to be able to deal with how we as humans think liability should sit in that environment.
And that kind of brings us on, doesn't it, to regulation and the need for regulation. I mean, and there's been some recent developments, particularly in the EU, and we can talk about the US as well. I think that will be interesting to see what the differences and the challenges are. But how are regulations dealing with the sort of AI liability space? And do we need specific regulation, or can we make do with a sort of an ex-ante bolt-on to existing regulations?
So I think, and obviously welcome views from the other panelists, and I work a lot in the EU, and the EU, as we all know, is an environment which is heavily regulated, and certainly tech regulation is coming thick and fast. You probably all have heard of the EU AI Act, which is effectively the EU's answer to AI, similar to the GDPR in terms of its impact and scale. The way the EU is dealing with this is to implement what I would call ex-ante regulation. It's about trying to prevent the harm that AI could cause earlier on. It's not about responding to the harm through a liability framework. And I think a lot of AI regulation that's coming through, including in the US, including in Asia, is all about targeting the development and/or the use of AI. So trying to tackle the problem at its source rather than trying to provide mechanisms for redress afterwards. And I think that's the holy grail, really, actually, is how you deal with the ex-post aspect of AI. When things go wrong, how do you do that? That's challenging, and I think that's part of the reason we're seeing this ex-ante regulation, implementing requirements for governance, making sure it's developed and used in the right way.
And how, and I'll come on, Danny, to the US before we talk about what's happening locally, but how does that work in practice? Can you give us an example of how the EU regulations are trying to grapple with that?
So one challenge that the EU's had to face, and all regulators have to face this, is do you regulate the technology itself? Do you regulate the way it's used? Or do you regulate outcomes? Now, a lot of regulation we have currently is aimed at humans, and it's aimed at outcomes. We say, don't cause discrimination as humans. But I always say, you can't rewire human brains very easily, but you can rewire machines. So AI gives us the opportunity to regulate the actual technology itself. It can say, make sure you develop that in a way which doesn't cause discrimination in the first place. But the problem is, if you regulate too heavily on the technology itself, you stifle innovation. And actually, some of the harms caused by AI are caused by the users. So you've got to find this tricky balance between regulating the technology and the use. And that's something that regulators are struggling with. So the EU AI Act actually does both. It principally targets use of AI, and it has a high-risk use regime, but it also targets the development of the most powerful models, which are called general-purpose AI models under the EU AI Act. So foundation models, frontier models, LLMs that Danny was talking about.
And Danny, is that a similar path? Is that reflected in the US regulatory regime as well, or are they approaching it in a different way?
No, it's quite the opposite. And I would take a step back and say I take a fairly global view to AI regulation. One of my mandates is as senior consultant to the UN on parliamentary engagement for artificial intelligence. And the goal there is, can we come up working with parliamentarians from several dozen countries on harmonized standards for AI? And the reason is AI is not a jurisdictional issue. The same reason that David Sachs in the US last night tweeted about jurisdictional patchworks in the US. We don't want 50 state laws of AI. We also don't want so many national laws on AI that we can't have the type of cooperation we need when the US and the Emirates work together on very, very important AI projects. So I think less is more on AI regulation, and we really need to focus on what the grave harms are. Let me say this, the EU AI Act, I have a lot of respect for the people who worked on it. I, on behalf of clients, was engaged in working on that law, but it's been very controversial, and I can tell you the private sector has made decisions on where to innovate based on that law, and the fear of some of the administrative burdens that it creates a priori, the ex ante rather than ex post. So regulation does have consequences, even to the point where now I think the EU is rethinking some of the deadlines and some of the impacts of that law, and there's some proposals along those lines. I would say we know what the most serious harms are that AI can cause, and I think countries need to work together on those. The rest, I think a lot can be handled through laws of general application and the tort system. I agree with Manesh. I think it's a good point that there's a lot of new challenges to applying old laws to AI. But at the same time, I think it's going to be a fool's errand to come up with a law of AI in advance. I'll give you one example, and then I'll pass. But I was on a panel in Geneva, and there was one of the authors of the EU AI Act, and they were asked to give an example of a lower risk use of AI, and they said chatbots. Well, if you look in the United States today, all the federal regulatory, all the state regulatory, all the litigation focused on chatbots. Chatbots, it turns out, can do just about anything. So we're not very good at predicting where the technology is going in advance, so I think we need something like a common law that's much more adaptable.
And we'll come on to talk about that, because that's obviously one of the features of common law. But just sticking with regulations for the time being, Magda and Donia, what are you seeing in the Emirates in terms of the regulatory landscape? And do you think that that we should sort of hold back slightly and see how things work out in Europe and the US, or is there a drive to our own domestic regulatory regime?
Yeah, so what I think has been fantastic about this region generally is that actually since 2017, when they appointed the AI minister here, this has been a conversation that's been ongoing. So before OpenAI, before Sam Altman, before this was a conversation in the EU, this was already being, a conversation. The opportunities, the challenges were already being looked at here. And what that's produced is an environment which is really, really pro-innovation, but also pro kind of testing. So does the approach that the EU are aligned with, does that work? Does the approach that the US is talking about, does that work? So we're taking a kind of a speculative view and kind of testing, and actually there's a lot of regulatory sandbox in operation and in discussion in this region, which I think are really, really helpful and will align with the point that was just made in terms of, we don't know exactly the harms that can be caused, and the speed of the development of this technology is so fast, we need to move at the same pace. I think what's also fantastic about this region, kind of just generally, and even just looking around the room, it's a testament to the collaborative approach and the cultural, the language diversity that we have here. Some of the things that we're talking about when we look at global approaches to regulation, and specifically in relation to AI, is how can you do that? How can you apply that to such a broad range of interests, to cultural and language diversity, which sits in such a breadth and the interesting world that we live in. So that's a challenge that the UAE is continually looking at as well.
And I think, Antonio, do you subscribe to the view that an over-regulated environment stifles innovation?
I do, actually, yes. We are very much pro-innovation, and often, at G42 we need to move very, very quickly. So as Magda alluded to and the other panelists, technological advancements are kind of moving at such a fast pace, the regulation can't keep up. So as lawyers in-house, it can be challenging as well as to how you can advise the business. That said, I do think there's a benefit to looking at the regulations that are in existence now, and I do wonder if the EU AI Act, whilst I think I have some issues with the act and how it approaches AI, will it become a little bit like the GDPR in the sense that will we start to look at it as an international guide? And I can already sense internally at G42 that we are, very much focused on the EU AI Act, and we're actually in the process of doing a regulatory analysis to understand how those regulations could touch upon our business, particularly as we're looking at EU expansion. But we've also set up an RAI function that's dedicated to this topic. And of course, very important for us that when we're deploying or developing products, that we're looking at the safety of these products and thinking about ethics. And so as part of that, we're not just looking at regulations, we're also looking at international standards and frameworks. For example, the ones that we are very much focused on are the NIST AI framework. We're looking at the OECD AI principles, the G7 Hiroshima International Principles. So I think there's enough out there that can help guide us in the interim.
But fundamentally, I agree. I mean, I remember when I first came out, we were looking at financial regulation, and everyone looks at and tries to get a best-in-class regulatory regime based on global standards, but they're not always fit for purpose in the region because Abu Dhabi is a leader in AI innovation, and again, you don't want to stifle innovation. And some of these regimes are just not suitable. I think that's probably where we land. And going back to the common law, so what else is it that, just leaving aside the sort of statutory and the regulatory regime, and we're touching on, Danny, I think we're coming on to the subject of what you were speaking about earlier. What else are lawyers doing to sort of foster this sort of, new AI environment? We talked about the laws of negligence and the laws of contract, and in the common law, for example, for those of you at civil law trained, we call it judge-made law, and for many, a couple of centuries at least in the UK, it's adapted to new technologies, and the common law is very adaptive. Why should we not just leave this to judges?
Yeah.
That wasn't a rhetorical question, by the way.
Was that for me?
Danny, that one's for you, because I know you wanted to talk about this.
Well, I love it. I mean, this is my favorite topic. 10 years ago, I was a much younger lawyer and working on technology litigation, and my concern was, this was back when our technology was dumb, and it was still too hard and too expensive to litigate. And all the seeds of what we're seeing in the disruption of the law today were apparent back then. There was a case on unintended acceleration in motor vehicles, and one of the opinions, the judge said, you know what, I've looked at all these expert reports, and it's just too complicated, a pox on all your houses. And I started thinking about that, and I wrote a paper that was controversial at the time, but I said, this is going to flip the whole system of liability, because it's going to be too expensive for any plaintiff to prove who caused what when you have large tech stacks, trillions of parameters, lots of different people fine-tuning, changing, implementing, agentizing. How could any court system unscramble that egg? So, those things have in some ways come true. Europe has come out with a revised product liability directive saying we're going to flip the burden of proof. It's sort of guilty until proven innocent. I don't think that's a great solution, but it's a very hard problem. I will say, I think, and I do truly believe this, so many of the harms of AI can be prevented with easy things. And the problem is often that we get so focused on the fancy problems. What if the next generation of chatbots becomes general intelligence and does, really bad things? That's a government level problem. But people throwing out under-tested, under-resourced, poorly designed products that are capable of making medical decisions, legal decisions, financial decisions, that's a problem we know how to fix. We can fix it preemptively, working with companies on risk mitigation, which is 60% of what I do right now. Red teaming, bias testing. Those those are not hard to do. We can do them with legal privilege and get things fixed before they go to market. Then, if companies behave well and do those good things, which are not very hard, the rest we can sort out with litigation. So I think if we kind of don't get too distracted by the science fiction stuff and really focus on what could harm people and how do we stop that, I think we'll have some practical solutions.
And Minesh, what are you seeing in the market, just in terms of disputes that are starting to come out of the industry and the use of AI? What sort of disputes are you seeing in your practice?
I think it's interesting because I think we had a sense that with AI we'd get the sort of mammoth disputes which would go to the heart of who is liable when AI causes harm. But actually what we're seeing is sort of AI disputes spring up in various different legal areas. So I think the big area that probably most of you will be familiar with is IP and copyright. So there's a huge issue, a dichotomy between content creators and their rights and developers and their use of material to train models. And so that's played out in a few jurisdictions. In the US, in the UK, we've got a big case, Getty and Stability, which you may know about. In Germany, there was a very interesting decision just a few weeks ago. And there's no consensus on that. It does go to a sort of moral and anthropological idea about where we think the rights should lie when it comes to content. So IP's an area where this is playing out quite interestingly. And then there are a few other areas where it's playing out as well. HR and employment, I think, is going to be a huge space where AI is going to cause some issues. There's a claim at the moment in the US, a class action against Workday, and the claim is essentially that AI tools used in the recruitment process have caused discrimination. And it's a fairly simple theory, and you can understand why claims like that have arisen. So that's another area where I think we're going to see that. And we've already seen it in the US. We're going to see it in the EU. We've got it in the UK now. Class actions. They're becoming more attractive for claimants. The damages figures that we're seeing are becoming mind-boggling. And I think quite a lot of big classes are going to go after large developers for AI disputes. And then we've got some other interesting areas playing out. One of them is this concept that I used to talk about. It's coming back to the fore now, AI washing, where organizations make false claims about using AI or the extent to which they're using AI. And actually the SEC has fined organizations in the US for AI washing. And I think in the most egregious of cases, a company was saying they were doing all audits and tax returns via AI, but actually it was just a room full of people in India, I think, doing it all manually. So there are some really egregious cases like that. So we're starting to see different areas where this will pop up, and I think we'll start to see more of those.
And Danny, before I'll come on to Magda and Donia shortly, but Danny, I can't leave the subject of lawsuits and litigation without talking about what's happening in the States, because that's always a bit of a crazy place for litigation. I read something about generative AI hallucination lawsuits.
Yep.
What are they?
Well, so I got to work on the first two of those, and so I'll speak not about any particular case, but at a high level. But I actually think these are the most important currently AI litigations to be aware of, because hallucination is such a silly word. We like to talk about how generative or large language models hallucinate. I would love to erase that word from the computer science language. They don't hallucinate. Sometimes they're right and sometimes they're wrong. The way these models work, especially I'm talking about large language models, they don't have an inherent sense of facts, of truth, of right or wrong. They are large language models. I said that earlier. The key word is language. They're trained on language, and all they're doing is stringing words together based on the most common patterns in the training data. So if they tell you, if you show it a picture and say, is this a cat or a dog? It doesn't know if it's a cat or a dog. It's just looking at the images and saying, okay, that matches this pattern, so we'll string some words together that give you an answer. Most of the time, it gets it right, but sometimes it gets it wrong. And what people have to realize is none of the companies are saying these are large truth models or large fact models. They're large language models. So if we use them appropriately and we ground them in facts through technologies that are available to make them behave responsibly, then you can get to a product that's very effective. So that comes back to litigation. There was a case, it was the Air Canada case, and this was in Canada. It was sort of a small claims court, but the outcome got global attention, even though it was a really minor, silly kind of case, because a guy asked a chatbot, can I get a discount on a particular type of fare? And the chatbot said, yes, you can. Turns out that was false. And the court said, no, Air Canada, this Canadian airline, is responsible and bound by what its chatbot says, even though there were disclaimers all over the website that said, it's a chatbot, check the facts. It even gave that person a link to go click on it and read the actual policy. Had the person done it, the policy would have said no. So taking your point that sometimes US gets the image of crazy litigation, actually in the cases I worked on, they came out the opposite way. In favor of the chatbots because in the one published opinion, the court said no, that the chatbot told you, it said, this is an experimental tool, this is how it works, it's not the final source of truth, check your facts. So it's, we have laws to deal with that. Reasonable reliance. When something says don't rely on this, don't rely on it. Use it, it's very useful, but then go fact check. That's the responsibility of keeping humans in the loop. I actually think that should be a very optimistic point for everyone in the audience because, Mark made a great point on the last panel. We all feel some fear of replacement, but at least in the current state of affairs, humans have the most important role of all, which is making sure that what the AI tool encourages us to do is right. We're still the gatekeepers. We still have that ultimate need and authority to check the facts. That's going to inform the litigations on these hallucination lawsuits, but it's also going to inform safe and good human-centric AI.
And I should add, Danny, that view of crazy US litigation is my personal view, not Aiken's view.
And that goes for, I'm sure, everybody on the panel, speaking for ourselves.
So now moving on to Magda again and Donia. Obviously, in your institution, your companies, you're at the forefront of AI development. Do lawsuits or the potential for lawsuits sort of keep you awake at night? What are you doing to mitigate the potential for lawsuits in what it is you're developing? Magda, let's start with you.
Yeah, so if I may, actually, I'd love to draw on a couple of points that the panel's already mentioned. So I think responsible humans create responsible AI. The technology in itself isn't evil, isn't bad. So if we kind of work with the basis of AI should be used as an addition, as an advisor to enhance the human experience. We talk about AI for good and responsible AI. So I think responsible people can achieve that. And to add to a couple of the points that Danny was making, it's actually quite easy to do that if you take the time to kind of work it back and think about it. And actually, you can use a lot of your existing frameworks, existing policies, processes. I mean, how many of the businesses you work in already have quality management processes in place? If you look at some of the requirements of being a responsible AI provider, developer, and then some of the requirements of the EU AI Act, they really build upon principles that businesses are already undertaking, already achieving. And to add an element of AI responsibility into that wouldn't probably take a lot of resource or time and effort once you've kind of figured it out, of course. So doing things like keeping logs of your behavior, using quality data, the right amount of data to train your models, things like that are really, really easy wins. Monitoring the false positives, true positives from your models, ensuring that you're taking customer feedback. I mean, one of the key things that we've looked at is actually creating an AI kind of native workforce internally at AIQ and then within our customer so that they have the appropriate skills to know how to use the tools responsibly, and then also to understand how that they won't feel that kind of threat, or to use the tool as an enabler, as I say, for AI for good, for the betterment of their kind of work and general life balance.
And Donia, as your company has probably more of a global reach, doesn't it, with the number of companies it has now, 10 at the last count, but dotted around the globe. Is a sort of global environment something that's of a concern to you? Because don't you have to be on top of a global regulatory environment, and that adds another layer of complexity, doesn't it, to what you're pushing out?
Yeah, definitely. And that's exactly why we've established this responsible AI function that's dedicated to this. And that is going to be growing over time, but essentially will be composed of a multidisciplinary team, both, of course, scientists, but also your lawyers as well. And we currently have an RAI executive council that kind of is your strategic, I guess, governance body that's overseeing RAI in the company and across all of our portfolio companies. We then have a number of other kind of subsets, including an RAI review committee. And that committee is kind of touching upon some of the things that Magda said. They're focused at looking at the products, testing them. We do a lot of red tape testing as well, as Danny had alluded to ensure that, if we can fix a problem now before it goes out to market, then you're kind of saving on, potentially millions of litigation in the future. We also have a model repository, which allows us to kind of store all the models, but also keep a record of all of the risks that have been identified, and that allows you then to also identify potentially patterns and deal with issues as they arrive. So there's a number of things that we're doing. We also have RAI ambassadors, and including our legal team and myself, some of us having to upskill a lot in AI and being sent to, I've done a course in AI at MIT, I've got team members going to the Oxford Business School, so it's actually becoming an integral part now of our day-to-day jobs. And then, of course, looking just purely on the legal side, it's a little bit like the approach to the ex-ante regulations. We don't know yet how liability will be apportioned and who will be blamed, but contractually, if we can try to kind of reduce the risk, that's what we are focused on right now. So, as developers, for example, some typical things we'd be looking for would be maybe some undertakings on the deployer or user as to how they're using the AI, and there'll be restrictions on how they use that. And if they breach that, then that will probably be carved out of the indemnity. We'll look at audit rights as well, so we can monitor that. On the other hand, if we're using or deploying AI, we'll want representations and warranties from the other counterparty, particularly around the use of training data, IP infringement. So I think that's predominantly what we're kind of focused on at the moment.
Thank you. That's really interesting. I'm a non-AI guy, but I just found all that really interesting. Everything that you sort of have to think about in terms of your sort of global business. I'm just conscious of time. Closing remarks, just from each of the panelists. What is it you think that will change most dramatically in the next 5 years in terms of the disputes landscape and the use of AI? Let's start with you, Manish.
I think one word we haven't mentioned, but I think a lot of it comes back down to this, is trust. We've just got to be able to trust AI, and the more we trust it, hopefully the fewer disputes we'll have, and the more we'll be able to embrace its benefits. And I think all of the comments that we've had on stage, I think, go to the trust point. Just to give you a quick example, I flew here on an aeroplane. I have no idea how that aeroplane stays in the air safely, but I still trust it. And I wonder why that is. And I think a lot of it is because of good governance. Yes, there's regulation, but there's also responsible practice and good governance. There's a safety card, there's a safety demonstration. I know the pilots are trained. I see someone checking, inspecting the plane before we go. And I think the whole responsible AI movement, which is unbelievably important, is all about creating trust in AI. And that's going to be the currency, and I think really important for the future in avoiding disputes.
Danny, trust?
I'll give a negative and a positive. Negative, evidence. Deepfakes are going to make litigations so much harder because you can now fabricate evidence with almost no cost. That's the bad. The good, access to justice. Litigation, I've been a litigator my whole career. I've had cases last 10 years. That's too long. Justice takes time. It's too slow. It's too complicated. AI is going to give more people access to efficient justice more quickly.
Magda?
I think just on a couple of points that were made, in terms of the ubiquitous nature that we're going to see AI, if AI does become electricity, of course we'll see an increase in disputes. If it's everywhere. We're all using it. How many times has everyone looked at their iPhone during the time we've been talking? You know, we're all using it all of the time. So
Hopefully not much.
Yeah, you were listening very intently. So of course there's going to be more disputes. And I think as time goes on, with the trust element that you were just mentioning, with people evidencing what they're doing, why they're doing it, how they're doing it, then I think we'll be able to have a less litigious view of those disputes.
Donia, the last word to you.
Yeah, so with disputes increasing, I think over the next 5 years, you know, what I'm most interested in seeing is if we can actually end up, maybe not exactly with a market position, but right now there's a lot of uncertainty, right, and lots of jurisdictions approaching AI in a different way and different outcomes in cases. And I think, you know, for common law to develop, you need in a way more cases, more disputes, and you need more facts so that you can end up in a situation where perhaps we can create a little bit more certainty. And so that's what I'd like to see, because with certainty, perhaps over time, we can also then in turn reduce the litigation. Great.
Donia, Magda, Danny, Minesh, thank you very much. I really enjoyed it and learnt a lot. Thank you.
Thank you.